And here we are again at the Parents Estate Planning Law Firm in Acton, Massachusetts with our one and only David Feakes. And today we thought we would touch base on some of the most common mistakes, actually 6 to be specific, that David will review when parents are naming guardians for their children. So we are glad you're here. If you're here live with us, let us know, give us a like, or feel free to put a comment or question in the feed below. And if you're here on our replay, we will absolutely get your questions answered as well. So David, good morning.
Good morning, everyone. This morning I wanted to share with you the 6 most common mistakes that we see parents making when they name guardians for their kids. So I want to share those 6 mistakes for you. This is really for both for people who have already named guardians for your kids. I want to share the information with you so you can see if you've made any one or more of these 6 most common mistakes. But it's also for parents who've not yet named guardians for your kids, because it's helpful to know and what to keep an eye out for as you're going through that process, so you can make sure that you don't make one of these 6 most common mistakes. So here they are, 1 through 6. The first is that you've named a couple to act as guardians for your kids, but you haven't specifically said what should happen if something happens to the couple that you've named. In other words, what happens if they get divorced? What happens if one of the people in that couple dies, or is incapacitated, or can no longer serve? So for example, if you've named your sister and your brother-in-law, you want to make sure that you say, what happens if something happens to your sister? Can your brother-in-law serve as guardian alone for your children? In some cases, the answer may be yes, but in many cases, the answer may be no. And that needs to be clearly spelled out in your guardian nominations, so there's no question about what should happen if something should happen to the couple that you've named as your guardians. So that's number 1. Number 2 is that you've only named one possible guardian, and you haven't named backups. So for example, last week I engaged a new client, and I was looking at a plan that he had put in place, he and his wife had put in place through LegalZoom. Not uncommon, I see that come into my office. They had named his brother as their guardian. So I naturally said, what happens if something happens to your brother? He said, I have no idea. I've never thought about that before. And obviously, LegalZoom, in their process, hadn't taken him through the process of thinking more deeply about what should happen if something happens to your named guardian. So you always want to be thinking about alternates, because it's not hard to imagine a scenario in which you've named your brother as a guardian for your kids, and you are driving in a car with your brother, and you're both in an accident. So that's number 2. Number 3 is when people consider financial resources when they're naming guardians for their kids. You are choosing guardians for your kids because they are the people that you know and trust to raise your kids as close to the way that you would if you were still there. And that's the consideration. It's not, do they have enough money to pay for your kids? You want to make sure that you are leaving money to pay for the care of your kids. Ideally through a trust, but you want to make sure that there is enough financial resources that you've left behind to make sure that your kids are well cared for and that you're not creating a financial burden for your guardians. So that's number 3. Number 4 is that you've only named the guardians in your will. And this is very, very, very common. And it's what I see with families who've worked with what I would call a more traditional estate planning attorney. Somebody who doesn't focus their practice on families with young kids, maybe the attorney that their own parents used. And so what happens is you've only named guardians in your will. Well, here's the thing about wills. They are death documents, and they are only truly affected if you've actually died. Now, if you've died, obviously you have to have named your guardians in your wills, but here's the thing, you might not die. You might be incapacitated and not able to care for your kids, and your wills are not effective in that circumstance. So you want to make sure not only have you named guardians in your wills, but you want to make sure you take those long-term guardian nominations and carry them out into a separate document. In our office, it would just be a straight nomination of guardian form that would be affected in the event of your long-term incapacity. So that's number 4. Number 5, the 5th most common mistake that I see is that families fail to identify people that they would not want to be their guardians under any circumstances. In other words, failing to exclude people you know you don't want to be the guardians of your kids. pretty easy to do. It's a confidential exclusion of guardian in our office, and it helps people to identify the people they know they don't want, and to make sure there's a legal document in place to make sure that those people can't challenge the decision that the clients have actually made when the time comes, or if the time ever comes. And then finally, the sixth most common mistake that we see is that families only plan for the long term in terms of guardians and not the short term. So this is really where we're more unique among estate planning attorneys, and because we focus on families with young kids, we thought through these issues. But basically the issue is you want to make sure that you have short-term guardians in place for your kids. Those are the people who are close to where you live, who can come over and take care of your kids for the short term until your long-term guardians can arrive and take over the care of your kids. And again, that's what I see missing from most plans that I see come into my office that were done by another attorney. Most attorneys don't think about that issue. Most parents don't think about that issue. And as a result, most families don't plan for that issue. So you want to make sure that you are planning for that specifically. So that's the 6 most common mistakes. Again, for families who've already done the planning, think about all of those. Think about any of those mistakes were ones that you inadvertently made in your plan. You're still alive. There's plenty of time to fix it. It's never too late to fix it. And for families who've not done the planning, those are the kinds of things you want to be thinking about as you're doing the planning to make sure you don't make those mistakes. If you want to get our resource sheet on the 6 most common mistakes, what you want to do is go to our website, www.parentsesstateplanning.com, parentsesstateplanning.com. Click on our link in the banner, free resources, and you'll find the 6 most common mistakes, one sheet there on our resource page for you to download and read and hold on to, because when you do your planning, you want to make sure you're not making those 6 mistakes. So thanks again for joining us today. Happy to have shared this information with you.
Great. Thanks, David. And we'll make sure to put the link to that resource guide right here with the live broadcast. So look for more videos from the Parents Estate Planning Law Firm. Have a great day.
Take care.